Yes, sir.
My lord, this is a review petition.
Huh?
Your lordship passed an order asking the Panchayat authorities to resume charge by someone.
Huh?
Actually, after declaration of election,
Huh?
normally matter has to go to tribunal.
Hmm.
So we have some important law points. It can be taken up tomorrow.
Tomorrow.
Yes.
Why
Because
do I
otherwise,
come up?
she may take over the charge.
There is a difficulty. Once a writ petition is disposed, they have to trace it out, bring it on record. All those things have to be done. Review does not come simply like an IA.
Then lordship will
File it.
on Monday.
File it. If it doesn't
Yes,
come on
yes,
Monday, make a mention. We'll have it on Tuesday.
It is already filed. It is already filed.
If it does not come up on the Monday list,
Yes.
make a mention. You'll have a list on the on Friday. You'll get the Monday list.
Yes.
Make a mention. We'll then allow it. Yes.
Item number 2.
Item number
2.
Yes.
Just for 4 weeks of him.
Is it so necessary to mention item number 2? Can it not wait for its turn?
Lordship, because of
Huh?
medical emergency, the brief could not be prepared.
Sorry?
Because of medical emergency.
That could have been said once item number 1 is done.
I'm for the petitioner, Lordship.
Any objections?
Lordship, there is an interim order that may vacant.
At the request of the learned counsel for the parties, list this matter again. When?
After 4 weeks.
So,
After 4 weeks, interim order passed earlier continues.
Chief, I'd like to mention for reasoning of the secretary bail lordship out of the same matter, lordship.
There is a senior bench. Why before this court?
There is, as per roster, this court is dealing with the punishment up to 7 years, lordship. That is why I'm making mention here.
এখন আছে নেকি?
It's case up to 7 years.
ও নহয় আজি মিতালী বাইদেউ বহা নাই।
I didn't have filed yesterday, lordship.
You give the mention slips. The court master will verify. If there is a senior bench, it does not happen. If there is no senior bench, it will be listed.
Meet be please.
If there is no senior bench,
Senior bench is there.
Then
Punishment is will that level is before up to 7 years. No lordship. And the above 7 years. That
এখন কোর্ট
yes.
রোস্টার কোন কোর্ট
All justice will prepare.
রোস্টার give it if this bench can allow it will come up.
May it be pleases you, Lordship. Your Lordship, today, Your Lordship, one matter has been listed as item number 4, and I have been appointed as amicus curiae. Your Lordship, copy needed to be construct, Your Lordship. So kindly grant us some time, Your Lordship, to construct the petition copy.
Criminal appeal jail registry doesn't give a copy.
No, Your Lordship.
Registry has to provide it to you. It's a criminal appeal jail.
No,
You are appointed-
I have, Your Lordship, yesterday, Your Lordship, I went there, Your Lordship, searching for that, Your Lordship. Already, file has already been sent to the allotted court, Your Lordship. So I could not trace the document, Your Lordship. 1 week time may be granted, Your Lordship, to construct the file,
At
Your
the
Lordship.
request of the learned amicus, who submits that she is yet to be supplied a paper book of the appeal. Place this matter again on. Pick a date.
After 1 week, any day.
Choose a date.
8th of May.
8th of May.
Huh?
8th of May.
I'm deeply obliged.
আজি এখন নোটিশ আছে চাওকচোন আজি নোটিশ এখন আছে আৰ্জেন্ট মেটাৰ্স টু বি মেনশ্যন চাওকচোন আছে কি দিছে এইটোত সেইটোতো তেওঁ তাতে লিষ্ট হোৱা কিনি ন আদাৰৱাইজ আজি এখন এলাও কৰিব পাৰে হ'ব জাষ্টিছ শৰ্মা মই জাষ্টিছ ঠাকুৰীয়া আৰু জাষ্টিছ চেকিয়া আছেতো ঠাকুৰীয়া বাইদেউ আজি বহা নাই Yes.
Ma'am, please, sir.
Actually,
I'd like to mention item number 19.
19.
Anticipated bail matter.
Hmm.
For the last order, the FSL report was awaited.
It is still awaited. CD available, but FSL is not available.
Mr. Your name?
BH of the Lordship.
Details of the petitioner, the learned APP has submitted that the forensic laboratory report is yet awaited. List again on
Second.
13th of May, awaiting the FSL along with the up-to-date case diary. The interim order passed earlier continues.
May I please, Your Lordship? Lordship, I beg to mention item number 22 of the daily list, Lordship. Item number 22 of the daily list, my senior Mr. S. Munir is out of station, madam. The matter may kindly be adjourned.
Mr. So-and-so appears, your name?
M. Ali, ma'am.
Mr. Emily appears for the petitioner. The honored APP has submitted that the CD is awaited.
7th of May.
List again on the 7th of May. 7th of May, full stop. Interim orders passed earlier shall continue.
Obliged.
We beg to mention item number 20, Your Lordship. In this matter, senior counsel H.R. Chaudhary is going to look for this case today, Your Lordship. Otherwise, in this matter, charge sheet submitted, Your Lordship. Interim is there, so maybe closed, Your Lordship.
When the matter comes up.
Obliged.
Yes.
Just would like to mention item number 25.
25.
Case diary is not available. There's an interim order, madam.
Mr. So-and-so appears for the petitioner. Learned APP has submitted that the case diary is awaited. List the matter again on
Interim is there, 11th of May.
11th of May. Interim order passed earlier continues.
I'm deeply obliged.
Maybe little Lordship. Lordship fixed a matter, exact a matter for tomorrow's matter with the September 14, my Lordship. Somehow this matter did not come in supplementary list, my Lordship.
I did not understand.
Your Lordship, yesterday fixed a matter with non-availability of CD because same set of matter today is the hearing on the court number 14. For that reason, your Lordship fixed the matter in that particular court number 14. But that particular matter today did not come in a supplementary list, my Lordship.
For court number 14?
Yes, my Lordship.
So if it has not come in court number 14, how can I pass an order here?
My Lordship, your Lordship has tracked the matter for today and it is in the e-court, it is showing the 22 is the next hearing date. That is today, my Lordship.
You go and tell the registry. They'll run for it.
That 23rd is my item, my Lord.
Huh?
23rd is my item, my Lord.
You have to go and tell the court that there is another connected matter, have it after some time. Then you go to the registry, tell them that if this matter does not come up today, there will be some action. Then the registry will do what they have to do. Have we to teach you that? You don't have a senior to teach you that.
May I please, Your Lordship?
Yes.
I beg to mention supplementary list bail hearing matter, Your Lordship. 49.
Yes.
State matter, but I am engaging Your Lordship 49. I withdraw this petition, Your Lordship.
Okay, only in item 49, huh? Your name?
Yes, Islam.
Mr. S. Islam, and the counsel for the petitioner has submitted that he is under instructions not to present the bail petition.
May it please, Your Lordship.
Your Lordship, item 47.
Please call him.
Tomorrow. It is
For the testimony.
Just a minute. An order is being dictated.
Yes.
Are you in much of a hurry?
I am sorry, Your Lordship.
We are not passing an order now. You wait for item number 49.
Sorry, Your Lordship.
We'll do it when the matter reaches. Yes, next.
Item,
Do you strike out that order? We'll do it when the matter reaches.
sorry, apply, Lordship.
Yes.
47 and 48, Lordship.
Huh?
47 and
Huh?
48, Lordship.
Huh?
If not tomorrow, Lordship, it is Lordship.
CD has come.
On Lordship. Yeah.
On the way.
Lordship.
Who told you?
Tomorrow,
Who told you?
party has the
Phone number of the IO. Please take a note of what has been submitted in the court.
Lordship, the party has informed me, Lordship.
We will see what the IO is doing in the matter.
They are supposed before the.
Mr. Gogoi is here in the court. Please inform him. Let the matter reach. Have him here. Let the matter reach. We will see. We'll fix it tomorrow. Let the matter reach. Yes.
Please, Your Lordship. I beg to mention for item number 8,
Hmm.
with consent of other side, Lordship. Lordship, matter may be taken after 2 weeks. Kindly.
After 2 weeks.
Lordship.
At the request of the learned counsel for the petitioner, with the consent of the learned counsel for the respondents, list this matter again on any date.
Any date, Lordship, after.
You want a date? Tell us a date.
14th of May, Lordship.
14th of May.
May I please, Your Lordship? Lordship, I beg to mention item number 31, Lordship.
31.
Lordship. Lordship, I may be allowed to withdraw this matter, Lordship. There have
The
some
counsel for
technical.
the petitioner has sought for leave to withdraw this petition in the present form. According leave is
31.
granted. Anticipated bail petition is closed on withdrawal.
Lordship, with liberty to file a fresh, Lordship.
Then you have to say praise for leave to withdraw this anticipated bail petition with liberty to file afresh.
Lordship, obliged.
Leave is granted. Anticipated bail petition is closed with leave as prayed for.
Lordship, obliged.
Yes,
Chair, beg to mention item number 33.
33.
Of the The petitioner has been arrested, so the application has been.
Learned counsel for the petitioner submits that during the pendency of this petition, the petitioner has been taken into custody. Accordingly, this anticipatory bail petition is closed, giving liberty to the petitioner to follow, to pursue such legal remedies as may be available to him. Yes,
May please, Your Lordship, item number 44.
44.
The matter may be passed over for the day, Lordship.
At the request of the learned counsel for the petitioner,
44.
44.
Oh.
The consent of the learned APP lists this matter again on, yes, when?
Any date, Lordship.
Lists this matter on any day.
Pass over for the day only.
We have to give dates. Give us a date.
I see. That's 30, Lordship.
30th of April 2026. Yes, madam?
To mention item number 51 of supplementary research.
51. Yes.
Pass over for a day, madam.
Huh?
It is not. It is not.
Ms. So-and-so appears for the petitioner. Learned PP has submitted that the CD is awaited. List the matter again on
Okay, madam.
5th of May.
Interim order.
The interim order passed earlier continues.
May it please, Your
Huh?
Lordship. Your Lordship, with the consent of the other side, I would beg to mention item number 3, Your Lordship.
3.
Yes, Your Lordship.
Yes.
Since my senior is in bereavement, Your Lordship.
Your name?
Lordship A. Das.
Miss, on the request of Mr. Adas, who has informed this court that the learned counsel for the petitioner is in bereavement, list this matter again on criminal petition. 8th of May?
Yes, Your Lordship.
7th of May.
7th of May? 7th of May.
Your Lordship, there is an interim order.
The interim order passed earlier continues.
Oblige, Your Lordship.
May I please, Your Lordship? Lordship, item number 7.
7?
Yes, Lordship.
Yes.
With consent of other side, only adjourn for the day, Lordship.
At the request of the learned counsel for the petitioner and the consent of the learned counsel for the respondent, list this matter again on 30th of April,
Lordship.
8th of May. 8th of May.
Item number 9,
Yes.
matter is await for service report. So let it come some other day, my lord.
Learned counsel appearing for the petition. You are for the petitioner, sir?
Yes.
And the counsel appearing for the petitioner has submitted that the service report is awaited.
My name not shown in the cause list, my lord. I have signed a vocal my lord.
Okay.
That my name may be shown, my lord.
But there is only one respondent, state of
No,
Assam.
no. I am for petition appellant.
Yes, there is only one respondent.
Yes.
So
no.
what
my
kind
lord.
of a service?
This is POCSO matter, my lord. Respondent number 2 is there, my lord. One bail petition, my lord, that is for suspension, that is pending.
Hmm?
9.
It's not too soon.
I had to deal.
Office note dated 27/3/2026 reflects that reflects that You have not taken steps in the
No,
IS.
steps I have taken, my lord.
You have taken steps in the
Main,
appeal.
but we
Not
have
in-
attached that copy of that bail application also, my lord, sent. That is there, my lord. We have sent.
There is an order in the IA. to
My
take
lord,
steps.
my lord.
I think you have to take
My lord,
steps.
my lord.
Office note dated 27/3/2026 in the appeal reflects that although notices have been issued, there is no service report full stop. List again on, yes, when do you want it?
Second week of May.
On the 11th of May,
Yes, yes.
2026. Huh? 15th, on the 15th of May.
Yes.
Huh. The name of Mr. B.B. Gogoi, learned counsel appearing for the appellant, be reflected in the cause list. Yes. 35. Ms. So-and-so appears for the petitioner. Learned APP has submitted that the CD has not been received. List again on 5th of May. 5th, 7th. Interim not there. 4th of May, 2026. Awaiting the CD.
motion ID item 1.
Finally, may I please, Lordship? My lord, this is 482 application, my lord. I am seeking transit pre-arrest bail.
Hmm?
My lord, some online fraud has been committed in the state of Delhi, my lord.
Hmm.
I am from Assam, my lord. So, my lord, I am submitting some orders passed by our coordinate benches, my lord.
Hmm.
So, limited protection may be given. I will appear before the investigation agency and
The similar matter
my lord, similar.
or the same FIR?
No,
Not the same FIR.
Other different cases, my lord. Coordinate benches. My lord. Fine.
Notice is annexure 2, page 21.
Hmm.
Requesting you to appear on 19/3/26. Is a resident of Borpeta, legal check, this physical, but why not appear? What is his difficulty to appear? Not appear on that thing. As per PI.
What other difficulty? What difficulty other than that he's going to be picked up on the way? When was the date to appear?
My lord.
19/3.
93, my lord.
Why did you not appear
My lord,
on
due to some
19/3?
illness, my lord. I
Where?
could not-
Have you stated?
My lord,
Have you stated?
my lord, para 8, my lord.
Para?
8. Page number 9, para 8, my lord.
Yes, Mr. Parashar. He says illness and threat of torture
My lord.
by the investigating agency.
As per PI, specific,
15 or 20.
You appear on or before
No, he has to approve the
Jurisdictional court. On or before, or did I say appear? I said appear, no. You appear the jurisdictional court on or before when? Tell us.
3 weeks time, maybe
4th of May.
4th of May, my lord.
Huh?
My lord,
Today is 22nd.
my lord. My lord, after 10, my lord. After 10, my lord.
Huh?
After 10, any date, my lord.
After?
10 May,
After 10th May.
any date.
On or before 11th of May?
My lord.
Okay, I'll dictate the order in the.
My
Huh?
lord. I have Solimuddin read 5 number paragraph. My lord, in Solimuddin case, my lord. Hello.
It will dispose to me.
For admission, item 5.
Wait, please, Your Lordship. This is that earlier matter, Lordship.
What happened?
Lordship, we have no
No
contact with
contact.
him. No contact with him. We tried.
Lordship can dispose of the.
We on the last occasion we had sent back the original records, retaining a scan copy. Did you approach the trial court for execution?
The records have reached very late, Lordship. Today they will take steps, Lordship, for warrant.
And what do we do with this? Should we say that, should we record your submission that he is not in touch with you?
Yes, Lordship.
And therefore, we are adjourning this case sine die without a stay.
Yes, Lordship.
To be.
Because yesterday also, we tried to contact him 4-5 times, but he did not pick up the call.
Otherwise, a concurrent finding, Lordship.
How will close it?
Courts below.
We'll close it.
Lordship.
Both the orders are reasoned, Lordship.
Lordship, rather than closing, Lordship, if one more opportunity, if we can connect with him at
By
least
when? Give us a date.
after if Lordship 2 weeks time may be given, at least, Lordship.
We'll have it on the 7th of May.
Yes, Lord.
Let him make one more attempt.
In my humble submission, Lordship, regional court has Lordship very limited jurisdiction when concurrent findings are there and both the orders are on merit and detail and.
When your colleague is asking for a opportunity to try and contact his client, is it necessary that we pass an order today? We have vacated the stay. You are proceeding in the lower court. Is it not? Learned counsel for the petitioner has sought for an accommodation to make one final attempt to make final attempts to contact the client
Yes,
who is
Lord.
not responding.
The petitioner, Lordship.
Stop. Accordingly, list the matter again on 7th of May,
Lordship.
on which date the matter will be taken up for disposal. We'll dispose it that day.
Yes, Lord. Obliged.
Item 6.
May I please, Lordship challenge for passing of entire proceeding as well as setting aside the cognizance order in an NIAC proceeding. Lordship, TCR has already been received. Better we fix for a date for final hearing. We'll complete
Yes.
the hearing.
We'll admit it and fix it for hearing.
Date may be.
Is there a stay?
No.
There is no stay. You are proceeding there.
Yes.
Continue to proceed. Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard Mr. A. Rashid learned counsel appearing for the respondent. Admit this matter, list for hearing after 3 weeks. On 19th of May, Mr. Goswami appears for learned APP appears for the state.
Item 10.
May it please, my lord. This appeal preferred for appeal against acquittal, my lord. In NI case, my lord.
We'll admit it and list it for hearing, or
Yes.
has he been served? Accused?
No, my lord, for the first time.
Huh?
For the first time, my lord. Not
Oh.
my lord.
This for the first time. Heard Mr. M. Kolita and counsel appearing for the appellant. Mr. Goswami appears for the learned APP appears for the respondent number 1. No formal notice. Steps for service of notice on the respondent number 2 by speed post within a period of 1 week from today. List again on 19th of May with service report.
Hearing, here, I can get a.
My pleasure, lordship. Minus 483 application, my lord. FIR at case 12, my lord.
The report card, look like it's marked lordship. After this trial, reports are not yet received, lordship.
So far, my instruction is concerned, my lord, from Rongnia court, my lord. The LCR has been sent, my lord. So matter may be fixed at 2 p.m., my lord. Until then, report may come.
Tomorrow, lordship, because.
Tomorrow?
Tomorrow.
At 2, she will have to again find out
My
the request of the learned APP, learned counsel for the petitioner. List the matter again tomorrow. Learned APP shall verify whether the scanned copy of the TCR has been received.
Good.
Do kindly.
Item 12.
Lordship, we kindly pass over for the time being, Lordship.
May I please tell us? My lord, at first I'd like to place this arrest memo, my lord. The signature of the accused person was not taken. So.
Oh, accused person signature is missing this time.
Not missing, my. But the mandatory provisions is not followed by police. It is the father's signature is there, but accused signature is not there. And the fact of the case is that, my lord, a 22 years old boy is in custody, my lord, since 2nd March, out of an FIR of a 27 years old lady who is the mother of a child, my lord. And the whole incident, I am claiming that this is a concocted story alleged in the FIR just to, my lord, keep me inside, my lord. What happened, my lord? And the is a well drafted FIR, my lord. Kindly see page 4, para 4, my lord.
Yes. So,
Kindly see page 4, para 4. May I read, my lord?
Page 4,
para 4. Para 4, 5, and 6, my lord. This is the story behind this FIR, my lord.
Yes, sir, what do you say?
My lord, Unboxed story and all the.
Arrest memo. You have the CD? Look at the arrest memo. Signature of the arrested person is not.
Yes.
Technicality, it will raise a doubt on the arrest itself. Father is called, sign it, then you are chasing the man. What? I do not know.
Injured statement.
Hmm?
Injured.
Injured.
Person who got injury.
Where is the injury?
Item 14.
No, item
13, 1-3. 1-3. Some 27-year-old lady says, we met in Chennai. He married me in a temple. And then he has left me. This man is inside bars. Why?
And while her home is at Gulagat, she went to Thailakandi, filed affair at Sribhumi. How, my lord, everything is done in this way?
Yes, we are allowing it. We are allowing it. Anything in the CD which requires.
By fulfilling his identity, is made the relationship and affair.
FIR says he tried to convert me. So there is no hiding of identity is there.
Before the marriage. Before marriage.
They believe social media, nothing can be done.
Before marriage,
If someone believes social media, what can we do? Heard Mr. Swenson, learned counsel appearing for the petitioner, also heard the learned APP. The present petition has been filed under provisions of section 483 of the BNSS 2023 praying for grant of regular bail in connection with Nilam Bazar PS case number 21 of 2026, comma, in connection with which the petitioner had been taken into custody on 2/3/2026. Full stop. The learned counsel for the petitioner has submitted that the petitioner had gone to Chennai to serve as a security guard, and the informant was also present at Chennai, where the petitioner had helped her secure a job. However, when the petitioner could not secure jobs for her colleagues, the present colleagues, and there was some misunderstanding, the present FIR had been lodged. The learned counsel for the petitioner has submitted that the informant is a permanent resident of Gulaghat who has lodged the FIR at Nilam Bazar Sribhumi, alleging that she was taking shelter at Hailakandi. Full stop. The learned counsel for the petitioner has submitted that he is ready to cooperate with the investigation, and since he is a permanent resident of the locality, there is little or no chance of his absconding. Full stop. The learned counsel for the petitioner has also submitted that the arrest of the petitioner would suffer from legal flaw when the arrest memo under section 36 of the BNSS 2023 does not even contain the signature of the petitioner. Full stop. The learned, accordingly, the learned counsel for the petitioner has prayed that the petitioner may be released on bail, granted the privilege of bail under any conditions that this court may deem fit. So the learned APP has submitted that the allegations are serious and releasing the petitioner at this point of time may hamper or tamper with the investigation. The case diary has been received. Peruse the same. In the circumstances of the case and after considering the length of detention of the petitioner, who is aged about 21 years of age.
22 years.
22 years of age. You have written 21 years.
But actually, this is something like police written 22. So I have saying that 22.
In your petition, you
The
have
father of the petitioner says it's 21, but police written 22. So
who is aged about 21 years, according to the statement of the father of the petitioner, comma. This court is of the opinion that the petitioner can be granted the privilege of bail under strict conditions that he shall not influence the informant or any other witnesses in the matter during the period of bail. Full stop. Accordingly, the petitioner shall be released on bail on furnishing a bond of rupees 20,000 with 2 sureties of the like amount to the satisfaction of the
CJM Sribhumi.
CJM Sribhumi in connection with, what is that case number? Neelam Bazar PS case number 21 of 2026. The petitioner shall also abide by the following conditions. That condition that we have given yesterday in the POCSO case, no? Huh? Not to contact, not to go in that locality and all. That part will come in, huh? Be
Alright.
disposed of. গোটেইকেইজন আহিছে আমাতে
Please. Item 47, 48, and 49. Come on.
They wanted a passover for tomorrow on the ground that the IO has informed that the CD is on the way. We just wanted to bring it to your notice. IO has informed.
Then I can.
IO has informed the Learned Counsel for the petition. What kind of a?
That is the reason, Lordship. I don't indicate in the
What
order.
pala nahi bill?
Lordship, Lordship. That should not be happen. Lordship.
No, you had made a statement.
That should not be happen, Lordship.
You had made a statement in the morning that you have information that the CD is on the way.
Lordship,
The petitioner and the IO are in
the-
contact.
Lordship, the party has at 8:16. Yeah.
As party, Lordship, party has come in, as parties are in, so Lordship may indicate in the order sheet, Lordship. Otherwise, Lordship.
Problem, let me
We
clarify.
will indicate it. Therefore, we wanted it.
Let me clarify, my lord. There are 3 items. 47, 48, and 49.
Yes.
My lord, I am not blaming him, my lord. What happened, my lord? The bail is pending here, item number 49. Now, my lord, he got bail in the lower court, my lord. The problem is that, my lord.
He approached 2 courts at the same time.
Same time, my lord. And he got
In
bail
item number
there.
49.
Yes, my lord.
Yes, we'll have that bail cancelled. No, we are not blaming you at any point of time. The petitioner had it done.
Yes.
The accused had it done. We'll indicate it. We'll direct the lower court to cancel that bail also. Otherwise, is there any option? Mr. Dotto, is there any other option?
I don't think so.
Paragraph
man.
16, Lordship, page 7, Lordship.
Huh?
49. 49, my lord, may page paragraph 16.
That is item 49.
49.
We are not on adjourning the matter as such.
Yes, man.
In the morning, when a prayer was made to withdraw the matter, we were allowing it. This statement was not made. While we were dictating the order, Learned Counsel walked away half through. So we said, wait till the matter is called for. We are not passing any orders. Now a new thing has come up.
The same thing, my lord. But what happened, my lord? If on the record, I'm submitting, my lord. My lord, same.
It's submitted. And allegations of the FI itself says that the lady is not at home. Is it not? And how many days?
85 days, man.
85 days already gone. Lady. Any children?
No, my lord, no silly.
Heard the Learned Counsel appearing for the petition. I also heard the Learned Mr. Swenson Learned APP. Full stop. The Learned Counsel for the petitioner. This is a petition under section 483. Can you do? In connection with DFU PS case number so and so. Learned APP has submitted that the charge sheet has been submitted by CS number.
CS number 15/2026, dated 25/3/26.
The Learned Counsel for the petitioner has submitted that the petitioner has already spent about 85 days in custody. And since now that the investigation is complete and a charge sheet has been submitted, the petitioner can be allowed the privilege of a bail as she is ready to participate in the trial if put up for the same. Full stop. The Learned APP has submitted that releasing the petitioner at this stage may not be feasible because since the trial is yet to start and the evidence is yet to be taken. Full stop. Having considered the length of detention suffered by the petitioner, who is a lady or aged about 51 years of age, and the contents of the FIR, which also contents of the FIR and the fact that the charge sheet has already been submitted, comma, this court deems it fit to allow the petitioner the privilege of bail at this stage. Full stop. Accordingly, the petitioner shall be released. It is directed that the petitioner shall be released on bail on furnishing a bond of rupees 40,000 with two sureties of the like amount, comma, one of whom shall be a government servant, to the satisfaction of the learned trial court. Trial court is what? Learned?
Dipu Mele Session Karbi Anglam Dipu.
Subject to the satisfaction of the learned session just Dipu.
Karbi Anglam Dipu.
Learned trial court. Learned trial court. Stop. The learned trial court shall be at liberty to impose such other conditions as may be necessary to ensure the participation of the petitioner in the trial proceedings. Be disposed of.
17.
May I please your lordship? Regular bail application. I was arrested on 28/2/2026, 53 days behind the bar. Now I am the bread earner of the family.
He not been, for the second day, he not.
Actually, behind the bar since 53 days. Further custodial interrogation may not be required. Allegation is that on 27/2/2026, one Hussain Ali lodged an FIR stating that the accused person and complainant have a pending land dispute before the court. And I am not the owner of any land. I am just the cultivator of the land. And on that day when the fight arises, I went there for cultivation purpose and I tried to break up the fight. And I was not there to assault anyone, and nothing has been recovered from my possession. No weapon has been recovered.
Huh?
I'm the bread earner of the family.
One person succumbed to his injury.
He is named in the FIR. Is he named in the FIR?
Yes, Kudrat Ali.
He is named in the FIR.
Court.
Already the person has died. What to do?
Lordship, I am the cultivator of the land. And in the FIR, it is mentioned that there is a land dispute between the parties. But I am not the owner of the land. I am just the cultivator of the land. I am doing the cultivation.
Today you are saying 53 days.
53 days.
When earliest can you have it? 8/4 CD was called for.
Yes.
30th of April. Learned APP has submitted that the CD is awaited. Stop. Learned counsel for the petitioner has submitted that the petitioner has already suffered 53 days of incarceration. Place this matter again on the 30th of April, allowing the learned PP to ensure that the CD, that the updated CD is placed before this court on the next date. 30th.
May it please, Lordship.
Yes. You are for?
For arresting not to Lordship.
What do you say? Why?
You will schedule meeting with the case, right? It's not a POCSO case, Lordship. Sir, under section 87 of PLS. Criminal case. The victim statement, maybe at this stage, but receiving the CD. Other section may include, but in the statement of the guard.
What is the statement of the guard?
No, CD is not available.
Awaited. When arrested? 20 दिन sir, 30 दिन. Huh? When?
21st March.
No, when do you want it? CD by when? 29th? 29th of April. List again on the 29th of April, allowing the learned EPP to have the case diary.
May I please, your lordship? It's a regular bail application, lordship. Offense, lordship, under section 118 and 109 of BNS, lordship. The accused person arrested on 28/8/2025, lordship. As on date, lordship, 238 days behind the bar, lordship. And the informant is the wife of the present petitioner, lordship. The allegation, lordship, a family dispute, lordship, between husband and wife, lordship. The allegation, lordship, on 27/8/2025, lordship, Usha Devi, the present petitioner, lodged an her lordship, alleging that she married with Bhupen Nath in the year 1999. Since the very inception of her marriage, her husband used to torture her and assaulted her with fist and blows, lordship. That yesterday, suddenly her husband started abusing her son, and when she received, lordship.
Received.
Production and
What does the son say?
said that father is to he is a habitual drinker and he used to torture with his mother.
How many days behind bar still now?
238 days, almost lordship, 8 months, lordship. And lordship, search sheet submitted, lordship, within 4 days of the incident, lordship. On 31/8/2025, lordship, till that, lordship, no any witness has been examined, lordship.
No witnesses examined?
Yes, lordship. And charges already framed, lordship, under the same section, lordship.
Heard Mr. Swensolan counsel paying for the petition. You are sure there is no witness examined, madam? Heard Mr. Swensolan counsel paying for the petition. Also heard Ms. Swensolan APP.
10,026 production and evidence.
Ms. Swenson, learned APP, full stop. The learned counsel for the petitioner has drawn attention of this court to the FIR lodged, where there were allegations that the petitioner had physically assaulted his wife and his son in a state of intoxication. Stop. The learned counsel for the petitioner has submitted that the charge sheet had been submitted 4 days after the alleged incident.
Yes, Lord.
Which took place on, when was the FIR dated? 28/8/2025, full stop. The learned counsel for the petitioner has submitted that till date, no witnesses have been examined in the matter and the trial is not proceeding.
Yes, Lord.
Any further? Stop. The learned counsel for the petitioner has further submitted that the petitioner shall participate in the trial.
Yes, Lord.
Under any conditions imposed upon him, if he is granted the privilege of a bail, full stop, having regard to the case of the trial and also the fact that the charge sheet had been submitted within 4 days. And the petitioner has already suffered incarceration. The length of detention of the petitioner, this court is of the opinion that the petitioner can be granted the privilege of bail, full stop. Accordingly, 30,000, 2 sureties of the like amount to the satisfaction of the learned trial court. Learned trial court will be at liberty to impose such conditions as will be necessary to ensure the presence of the petitioner during the trial proceedings. Be disposed of.
He's a PT businessman, lordship. If lordship one surety, lordship, one surety, lordship, he's a PT businessman, lordship. The small shop is there, lordship, in Tinsukia, lordship.
Yes, you have
I
that order.
preparing my lord, yes, my lord. On behalf of my lord, SK Nargis, my lord.
Have you seen that order?
Yes, sir. I have done for that. Yes. Sir.
There's no option. The second arrest is to go.
I got the appointment.
Second detention is to go.
My lord, order.
Heard the Ms. Nargis Narat counsel paying for the petitioner, also heard
14-1 for.
the
Hello.
learned APP. The learned counsel for the petitioner has submitted that this is a petition paying for bail in connection with details of the case to deliver special NDPS case for association. Learned counsel for the petitioner has submitted that the petitioner was already arrested in connection with
Special NDPS case number, my lord.
originally which case he was
First arrested, my lord.
This case is Bhuleshwar PS case number 32/2020.
He was already.
And earlier arrested in my Tamulpur PS case
Ah,
number
that the
170.
petitioner was already arrested in connection with Tamulpur PS case number
178, 2024.
And-
That is also NDPS, my lord.
which was under the NDPS Act, and the petitioner was thereafter shown arrested
Here in this case.
in connection with
In connection
Which is
with special NDPS case number
Huh.
15/2024, my lord.
24.
Arising out of Goreshwar PS case number 32/2024, my lord.
2024. ठीक है?
First page, my lord.
Gauhati PS case number 32 of 2024. The learned counsel for the petitioner had submitted that the second, the detention, the continued detention of the petitioner in connection with the second, with Gauhati PS case number 32 of 2024 suffers from legal infirmities since the petitioner had never been informed of the grounds of his arrest and detention in connection with the said case, full stop. The learned APP has submitted that the petitioner had been arrested in connection with Gauhati PS case number 32 of 2024 on the strength of a order.
Strength of the production.
Production
Ah.
warrant.
Strength of a production warrant issued by the competent court, and therefore there is no illegality in the arrest of the petitioner. The learned counsel for the petitioner has submitted that it is a settled position of law that when a person is not informed about the grounds of his production in connection with a case in which a production warrant is issued, and he is further shown to be arrested in connection with the second case also, comma, there in the absence of any reasons being told to the arrested person, comma, the further detention of the arrested person would become unconstitutional, drawing our attention to the order dated 18/8/2025 passed in bail application number 2003 of 2025. The learned counsel for the petitioner has submitted that the constitutional mandate of protection against arrest and detention in certain cases as provided in Article 22(1) of the Constitution of India is applicable to courts of law also. The learned counsel has emphasized upon the duty of the learned trial court to furnish copies of whatever documents are referred to while passing an order of his being shown arrest in connection with a particular case. Full stop. The learned counsel for the petitioner has also submitted that the trial court has not recorded the ground of detention of the petitioner and the ground for remanding him to judicial custody in writing, and the non-communication to the petitioner regarding the ground of his remand to judicial custody would amount to violation of the fundamental rights of the petitioner guaranteed to him under Article 21 and Article 22 within bracket 1 of the Constitution of India. Full stop. The learned APP has submitted that the petitioner has been found to be an accused in at least 2 cases involving the NDPS Act, and release of the petitioner on bail may would not serve the purposes of justice, since there is a high probability that the petitioner may again engage in further nefarious activities. Full stop. Having considered the submissions of the learned counsel for the petitioner and the learned APP, this court is of the view that the learned court of
And special Judge Baksha, my lord.
that the learned subdivisional judicial magistrate Baksa,
Special
while
Judge-
allowing the petitioner to be shown arrested and further directing him to be taken into remand, does not disclose any reason for such a arrest or remand, full stop. There is nothing on record to show that the petitioner had been informed the reasons of his arrest, and therefore this court is inclined to grant bail to the petitioner, since the further detention of the petitioner after his illegal shown arrest is found to be in violation of the constitutional mandates, full stop. Accordingly, however, this court cannot lose sight of the fact that the petitioner has been found to be involved in at least 2 cases of NDPS, full stop. Therefore, strict conditions are liable to be imposed upon the petitioner while granting him the privilege of bail. Accordingly, the petitioner it is directed that the petitioner shall be released on bail on submitting bail bond of rupees 50, bail bond of 50,000 with 2 sureties of the like amount, one of which shall be a government servant, and at least one of whom shall have immovable property of the same value within the jurisdiction of the learned SDGM. What?
Special Judge Baksha, my lord. Special Judge.
Of the jurisdiction of the learned Special Judge Baksha. Full stop. আর বাকি হেগিটা আসলে NDPS এর বাকি কিটা আসলে যে পামিডি আনন্দ যে কিটা দিয়ে আসলে yes
Obliged, my lord.
disposed of. এই দুটা ভাই
May I please, sir?
Yes.
In this matter, charge sheet is filed, Your Lordship.
What do you want to do?
The petitioner was on interim, Your Lordship, interim protection.
Heard Mr. So-and-so learner counsel appearing for the petitioner. Also heard Mr. Bosho, learned APP, who has submitted that the charge sheet has been submitted by CS number
By CS number 7/2026.
dated
25/1/2026.
accordingly. The interim bail granted to the petitioner is made absolute. The petitioner shall appear before the learned trial court as and when summons are received.
Communication we have received that may be kept as part of the report.
What is the what does it say?
Regarding that such statement.
In other cases, you have never given us a communication. Why in this case? The communication to the learned APP by the officer in charge of the Algabur police station, informing him regarding the submission of the charge sheet, is kept in record and marked, kept as a part of the record and marked as annexure X, not annexure, marked as X. The annexure word still comes with.
Obliged.
Yes.
May it please your lordship. My lord, here, after the interim bail, my lord, petitioner is a this branch credit manager of Solamandalam, that finance institution, my lord. He appeared before the IO. And
Where they had transferred some money and then
no
it was
transfer,
refunded back.
not a single rupee, and allegation of
Some OTP was taken.
Yes,
that
yes,
matter.
OTP.
Okay.
OTP was, my lord, bona fidely actually used to withdraw his complaint because of the complaint we could not top up the loan. So we bona fidely.
Yes. His statement that he has record. In such a case, would you require a custodial interrogation?
Allegation of embezzlement is.
One man is running for his life. Why every day? Heard Mr. T.S. Hazarika, learned counsel appearing for the petitioners. Also heard Mr. Mr. Bushel, learned counsel, learned APP in the matter. Full stop. This court had granted an interim protection to the petitioner by the order dated 19/12/2025, with directions to the petitioner to appear before the investigating officer and cooperate with the investigation. Full stop. The learned counsel for the petitioner has submitted that the petitioner has already appeared before the investigating officer and produced all materials that were with him to aid the investigation. Full stop. This court notices that the case diary could not be produced on the 4th of February 2026, 20th of February 2026, 18/3/2026, and also today. Full stop.
For date.
In the above circumstances, this court is of the opinion that the interim protection granted to the petitioner can be made absolute, subject to the condition that the petitioner shall appear before the investigating authority as and when required to do so, full stop. Failure of the petitioner to abide by the terms of the bail may be brought to the notice of the appropriate court for reconsideration of the bail.
My lord, that.
May be disposed of. Yes.
Reconsideration.
In case you don't abide.
All right. Deeply obliged, my lord. Deeply.
We are disposing of the AB. We have made
Yes.
it absolute.
Yes.
In this case, my
Yes,
lord,
sir.
I was on interim, my lord.
Hmm.
My lord, I appeared before the IO, my lord.
Hmm.
The case raised, lordship will find the FIR at page 9, my lord. Page 9, my lord. It is respectfully stated that my brother's son, namely so-and-so, was recovered as hanging in his house because yesterday evening one Ashik Ahmed, along with 4 or 5 youths, had badly beaten Manav Mohanta and Dipanjali Mehdi. Well, I am Ashik Ahmed, my lord. I was granted interim bail on 30/01/2026. I appeared before the IO.
Yes, sir.
My lord, yes, my lord. After the interim, they have appeared, my lord. That the statement reveals, my lord, due to the triangular, my lord.
Laugh triangle.
And there was some,
There was some
any custodial interrogation required?
lawsuits, my lord.
Huh? No, love triangles, do you need custody of the person who is the third angle?
Because of that, my lord.
That question is very simple. We do not want you to say yes or no, but we are asking you out of curiosity whether a custodial interrogation would be required in such circumstances. The CCTV footage was there.
CCTV footage was.
The fight has been recorded.
Fight has been recorded, and yes, fight is there, and they have also admitted.
Fight has been recorded. Anybody guilty will be punished in accordance with law. Custodial interrogation till filing of the charge sheet is it required? Heard Mr. N.J. Dr. Leonard Counsel appearing for the petitioner, also heard Mr. Goswami Leonard APP appearing in the matter. Mr. Dr. Leonard Counsel appearing for the petitioner has submitted that the petitioner has already appeared before the investigating authority and cooperated with the investigation. Full stop. The Leonard APP has submitted that the case diary has been received, which reveals that the petitioner has participated in the investigation process. Full stop. Material seizures have also been made in the meantime. Full stop. In view of the above, this court is of the opinion that the custodial interrogation of the petitioner at this stage may not be necessary. Full stop. Accordingly, the interim protection granted to the petitioner on the earlier occasion is hereby made absolute, subject to the condition that the petitioner shall continue to participate and cooperate with the investigation as and when required by the investigating officer. Full stop. Any violation of the condition imposed upon the petitioner shall be brought to the notice, may be brought to the notice of the appropriate court, whereupon the bail shall be reconsidered. Full stop. Anticipatory bail petition accordingly disposed of.
I'm obliged.
My lord, may report the objection of that. I have another. That he has created objection regarding that since they are involved in accused in attaching the suicide, so his parents that mail may not be granted.
And the mother had to hit that the Learned APP has submitted that the investigating officer has prayed for the rejection of the prayer for anticipatory bail since what?
Since they are involved in
Since the petitioner is allegedly involved in abetting a suicide by one of the persons involved in the
abetting the suicide of the
fiasco.
My friend is appearing item 26, my lord. Same. She is there, my lord. God, the fool, my lord. Fool, do mali.
Another part of the angle.
The flower, huh?
I'm obliged.
The flower is what he's saying.
I'm obliged.
He to di দিব একেটা থাকিব গোটেইখিনি বস্তু খালি কনসোলৰ নামটো both disposed of.
94.
CD received.
Lordship, kindly pass over for timing.
But my
Pass over for timing, sir.
because it will let senior neighbor. Because as per the last note of the IML, though the interim was granted, he has not appeared till 10/3.
Till 10/3. We are in
No,
4.
Lordship,
We are at the end of 4.
Lordship,
He did not appear in March. We are now in April.
But we have received a CD on 22nd of April. By then also perhaps he has not appeared.
Lordship, he did appear 4-5 days, Lordship, but statement was not recorded. Even Lordship, when he did appear, he takes some photos and videographies from police station, Lordship.
And sends to you.
Yeah.
10 তারিখ 11 তারিখ এই যেতে interim
April.
Okay, ask your senior to be able. You are asking for a password for the time being. Time being. Kindly fix up a date. We'll give a date. Since he has made a statement that he tried to appear,
Yes, sir.
so we'll give a date, particular date, particular time. Let him go make an entry in the PS and
Lordship.
Instead of
lady senior.
27.
Yes, madam.
Yes, charge sheet has been submitted, my lord. And both the accused is went on bail at the Sibsagar CGM court.
Yeah.
No, I have. People?
25/3 on the 25/3 they went on bail, both the accused.
27.
Yes.
There is a bill pending here.
No, they already bail order. We have the bail order.
27. Same thing like model.
No, here it was an anticipatory bail petition.
Anticipatory.
They were granted anticipatory bail, requiring them to appear before the IO. Is it not? They were required to appear before the IO.
Yes.
Then the charge sheet was submitted in the meantime. So this is with regard to the investigation period. When the charge sheet was submitted, they appeared before the trial court and said, now give us a regular bail. Trial court gave a regular bail without reference to the AB. Because this was in investigation. That is in trial. Is it not?
After that, because I have not seen the order.
No, here they were given an interim to appear before the IO. So IO, they appeared. In the meantime, charge sheet filed. So they appeared before the court without reference. They don't need to refer to this in that case. No? We'll come back in 2 minutes. That will be a regular bill. Try and have the orders of the trial court if you can.
Yes.
If they can send it to you by WhatsApp,
Okay,
you can get a printout.
Okay.
We'll come back in 2-3 minutes. Did you get it?
Yes.
Was after the protection and the trial court has taken into account the fact that they have participated. The learned counsel for the petitioner, your Miss
A Devi.
A Devi has submitted that the final form in the present case had been submitted before the learned CGM Sibsagar, and they had, and while they had participated in the investigating process, they had also appeared before the learned CGM on 25/3/2026 after submission of the final form, and had prayed for a regular bail, which was allowed by the learned CGM, Sibsagar. In such circumstances, nothing survives in this anticipatory bail to be adjudicated upon. Since the petitioner have already been granted a regular bail by the learned trial court, accordingly, the anticipatory bail petition is closed. A
Duly obliged.
copy of the order dated 25/3/2026 passed by the learned CJM Sibsagar is kept on record as X. Disposed.
Duly obliged, my lord.
May it please your lordship. Pursuant to the order of this honorable court, your lordship, I have been directed to appear before the police station, your lordship, on 2/2/2016. And accordingly, your lordship, complying the order, I did appear, your lordship. So I went there on 5/3/2026 and thereafter.
Your colleague had made a submission that they have not recorded your presence or taken this
Yes,
statement.
Your Lordship. Yes.
So we'll fix a particular date. Go and appear on that particular date.
Lordship.
Yes, tell us convenience. Learned counsel for the petitioner has submitted all that, although the petitioner had approached the investigating officer pursuant to the pursuant to the directions given by this court, the learned APP on the other hand has submitted that the petitioner has failed to appear before the investigating authority. Full stop. Without going into the controversy, this court directs the petitioner to appear before the investigating officer on or before the 5th of May 2026 with prior intimation to the investigating officer on or before 5th of May 2026. Full stop. The investigating officer shall inform the petitioner the time and date on which he is required to appear before the investigating officer. Full stop. List again on 12th of May along with the updated list ID. Investigating officer shall inform বুলি কলো যে তাত আপুনি লিখক will be at liberty to inform a particular time and date requiring the
Instruction was sought, my lord, as to when I have to appear before the IO.
Same, you had gone to appear, they are not allowing you to appear.
No,
New technique.
he went there and on that day, the IO got expert to other place.
Now he's in some other this thing, what Hamreng.
Yes, in Butlansu.
He has to go and appear in Boithalangsu before the circle inspector. When? Tell us. The learned counsel for the petitioner submitted that despite efforts being made on behalf of the petitioner, his presence before the IO has not been recorded. Full stop. Then you say, Mr. Bora, learned counsel paying for the informant to assist the APP has submitted that the investigation has been transferred to the circle officer Boithalangsu and the petitioner has to appear before this aforesaid investigating officer, circle officer at Boithalangsu. Circle inspector at Boithalangsu, full stop. According, the petitioner shall appear before the circle officer Boithalangsu in connection with this case to assist the investigation on or before the 5th of May 2026. The updated CD will be produced before this court on 12th of May 2026. The circle inspector Boithalangsu shall be at liberty to inform the petitioner the time and date on which he is required to appear before the investigating authority. Full stop. List again on 12th of May.
Then, my lord, interim may be continued.
The interim continues.
Somewhere maybe a circle officer.
A circle officer, no, the circle inspector. You will assist him. Do you need to file another objection?
After that, should be on
12th of May. Mr. Bora Mr. Bora, paying for the informant may file his objections. এইটো মাজত লিখি থৈ দিব আৰু ক'ৰবাত। Yes, anything pending in the Hajju station?
And report was gone for lodging whether.
No case registered.
Huh? No case registered.
If they want a signal, no case registered.
Consequent to the order dated 24/2026, the learned APP has placed before this court a signal dated 21st of April 2026 to the effect that no such case is registered in the Hajo PS against the petitioner. Accordingly, this anticipatory bill petition does not need any further adjudication as of now. Full stop. Petition and is accordingly closed. Petitioner will be at liberty to approach this court to praying for appropriate relief in the event any if so required in the future.
Same or lodge.
Same order, both disposed of.
Right.
29 and 30, na? 29 and 30. Same order, huh?
Ab like.
From Panbazar.
I had to Haju to Panbazar koi dibo. Haju to Panbazar koi dibo.
May I please, Your Lordship?
Ah.
CD not received, Lordship.
CD not received. What is the allegation?
Murder, Lordship.
Wait. On the 11th, Leonard, Mr. So appears for the petitioner. Leonard PP has paid for accommodation to produce the CD. List again on 11th of May 2026.
34. 34.
Anticipatory bail application, connected matter with item number 17. Lordship, there was a fight on an agricultural land, and due to that fight, one person succumbed
What
to the injury.
was the order passed in item 17?
Lordship, two persons were already granted anticipatory bail by the learned Session Judge Nagaon.
Maybe VA.
Anticipatory bail. It is in page number 24.
No. Page number?
24.
Just a minute. We'll come to them.
Them no material.
See, none of these two fellows were there in the. They were named in the FIR. Abdul Wafa.
Yes, accused number 5. Sajjad Hussain.
Succumb to the injury.
Also,
It is seen that the witnesses have not implicated the present accused. The CD was produced there. This person was not found to be implicated by any of the witnesses. CCTV footage, he was at home at that particular point of time. Therefore, the anticipatory bail granted.
Lordship, accused one were also granted anticipatory bail.
Why?
Ilyas Hussain. It is in page number 21.
Page number?
21.
21. Anticipatory bail. Witnesses have not implicated the present accused at the time of the incident. So we'll have to, that is why the CD. If
My collective case speaks on 30th.
30th of April, list this matter along with item number 17 on heredity, huh? So and so on 30th of April 2026 since
BA 1025.
since they arise from the same FIR and the CD has already been called for. Not only an attempt to murder, but to bury a live person also. Dangerous.
36.
Yes. 36. PCR আহিলে here. Huh? PCR আহিছিল. কিহত আছে এইটো? None, it is for the appellant on call. Mr. Parshal and please present. Trial court records call for has been received. List this matter for hearing, for admission. Hearing. Appeal শুনিয়ে দিব পাৰি।
PCR legal counsel also appear
Fix it for hearing.
because
List the matter again for consideration on the 14th of May 2026 or earlier.
2024.
Maintenance. This for maintenance. Huh? 4th of May, 14th of May is fine. Maintenance. When the petitioner does not appear, what to do? Your Lordship, may it please, Your Lordship.
In fact, in the instant case, the NCR was called for, the same was received, Can you have it for admission hearing,
Yes, yes.
Can it be on 7th or 8th of May,
At the request of the trial court records called for have been received. At the request of the counsel for the parties, list this matter again on
7 or 8?
7th or 8th.
One flag, but Lordship, can you the order passed by the there was no stay in the instant case. Because the records were called, my lord. Magistrate, my lord, all.
What is in the planning? The other one, the trial court record. Warrant was stayed.
Yes. No stay order from this court, my lord.
You said the warrant was stayed.
Yes. Case not stayed, my lord.
Warrant was stayed.
Warrant stayed, but the case was not proceeded, my lord, thereafter, my lord.
Few more days.
Yes.
Few more days.
Yes.
7th of May is not far.
Yes.
It can be reissued or the recall can be 45.
Yes.
But for admission hearing.
Or list on the 7th of May. Remind us on that.
I'm very grateful, Your Lordship.
In the admission column to presence বিলাক লিখিব হা PDUD for the petitioner NJ Dotto for the respondent কে লিখিব yes
Item number 36.
এটো কিমান
38, Your Lordship.
let this matter happen, then we'll come to you. Yes.
May it please, Your Lordship. Lordship, on the last occasion, Lordship, the learned PP was supposed to take instructions from the concerned police station if service of notice respondent number 2 was complete, Your Lordship.
Yes. Respondent number 2, informant.
The informant, Your Lordship.
Someone is behind bars.
No, maybe 10 years conviction, someone may have taken for preparing the objection. Preparation of the objection, someone may have taken.
Oh, achha. Is a ground of appeal?
Lordship, the age determination of the victim, Your Lordship.
Hmm?
The age determination of.
How was it done?
Lordship, with the birth certificate, but the issuing authority was not examined, Your Lordship. And as per the statement of the father, Lordship, she was a student of an LP school, Your Lordship. No school certificate was also produced, Your Lordship.
It can be there, but
We took them again in the month of February, Your Lordship, 18th of February.
In that case, in the meantime, we will file objection,
18th of
February, Your Lordship.
there is nothing on record, madam. Your 18th of February is not on record. Eighteenth of February 2026.
Lordship.
Neither is there an order to that effect that you should again take steps.
Lordship, it's available in the case status, Your Lordship.
Okay. But then you see this confusion regarding the age.
Lordship.
14 to 18, there might be a confusion. Can there be a confusion between 7 years of age, 14 years of age, and 18 years of age? How far non-production of a document? Evidently, a child is 7 years. How far will it affect the
There's also some in
other grounds should be there, no doubt, but since that will be an issue when the matter is taken up, just trying to find out. Because 7-year-old girl and an 18-year-old girl, if there's a confusion whether she's 18, 16, 17, then perhaps an age certificate, a bone school certificate, all those questions will come in. Would you still need a certificate for a 3-year-old child, 7-year-old child?
I understand.
Would it not be beyond human reason to say that yes, 7-year-old has also to say that she is not she's a minor? That is by sight. That is only. If there's a confusion that 7 or below 12 or below 9, perhaps somewhere. But
18.
Whether POXO will come in or not, 7-year-old child, it's by sight. So it's by human reason. Is it not? Anyway, you are Miss?
S. Kataki, Your Lordship.
Miss S. Kataki, Learned Counsel appearing for the appellant, has submitted that all the steps were again taken in the month of March in the month of February 2026. However, the service report is awaited. This the records of the case does not reveal that any fresh steps are required to be taken under orders of this court. And further, there is no office note regarding the receipt of fresh steps. Accordingly, the counsel for the appellant is given the liberty to take fresh steps upon the respondent number 2 within a period of 1 week from today. List again on 29, then we'll have 6th, 13th. Or you suggest. 1-3 me. She will take steps by 29th. Then you would have the entire next 2 weeks. Perhaps because there was no earlier. Because there was no order, the registry has not accepted it here or given any office note.
Lordship.
And now we have an order.
Lordship.
List again on the 13th of May 2026 along with service report. Learned APP shall also have his instructions on the report of service of notice on the respondent number 2.
Obliged.
Item 36, yes. What is your name? Miss S. Bora, PS Bora. On behalf of Miss R.B. Bora. For respondent number 2. Itu item 36 ot itu bharai dibo. Record your name.
Actually, last occasion, direction was given to take steps to respond. Direction was given to take steps to respondent number 2. But I have verified it has not been taken. So small accommodation. Today itself,
Mr. Swensel, counsel for the petition for the petitioner has submitted that he may be allowed a further time of
weeks. Today itself we will take
a week to take fresh steps on the respondent number 2. Prayer is allowed. Steps to be taken within the next week, within a week from today. This is the matter again on 20th of May, 20 May, along with service report.
Obliged.
My lord, we have taken steps today, my lord.
The counsel for the Miss Swensel and a counsel appearing for the petitioner has submitted that the steps have been taken today in consequence of the earlier orders passed by this court. Accordingly, this matter again on the 22nd of May, along with service report.
There is an interim order, my
The
lord.
interim order passed earlier shall continue. If you have not taken the steps, we will vacate it on the next day.
Taken, my lord.
Get an interim and not take steps is dangerous. Yes. With reference to of the notice on the attached notice sent so attached ID proof will report after obtaining from him. Police report. Who's the respondent number 2 name? Served. Office note dated 24/7/2025. In IA Criminal 397 of 2025 reflects that the service in respect of respondent number 2 has been completed by the concerned police station and the proof of identity of the recipient has also been furnished. Full stop. Accordingly, service of notice on the respondent number 2 is deemed to be complete. Full stop. However, it will be complete list again on. We'll take it up on 27th of April. allowing him an opportunity to appear. On that day, we will appoint the amicus and close it, huh?
Hello.
This is what for condonation of delay?
Yes.
Eh? How many days? He's in jail. 14 days. The amicus. Or we'll do it this way, we'll appoint the amicus today itself. Huh? There is no appearance on behalf of the respondent number 2 today. Full stop. This is an application praying for condonation of delay of 14 days. Can't do a price also. PR? P. Agarwal. Accordingly, Dr. P. Agarwal, Learned Counsel, is appointed as an amicus in the matter to assist the court and defend the interests of the respondent number 2. Full stop. List the matter again on 27th of since now it goes to the appellant today, the learned APP shall take the pain of supplying a copy of the IA to the learned amicus appointed today. Supply one copy to the learned amicus. None has appeared today. He is in jail. Or should we say the registry should supply? Dr. P. Agarwal. Or only of the IA, not of the appeal. 42.
May I please have Lordship? Lordship, in IA 428/2025, Mr. S.C. Vishal is appearing for the petitioner. Lordship, kindly have a copy of an answer.
I did not understand.
Lordship, in IA 428/2005, Mr. S.C. Vishal is appearing for the petitioner. That the copy may be served upon us. It's a legal aid matter.
Who appointed you as a legal aid? The legal aid authority. They'll supply you a copy while appointing you. They have not supplied you a copy while appointing you. Criminal appeal jail. 195 days. Mr. Parashar, 195 days. POCSO. What is your name?
Devasri Chakraborty.
Ms. Lee Chakraborty, Learned Counsel, appears on behalf of Mr. S.C. Biswas, who is stated to be the legal aid counsel in the matter. Full stop. So, Parashar appears for the state of Assam. Full stop. This is an application under Section 5 of the Limitation Act, paying for condonation of delay of 195 days in filing the connected criminal appeal. Full stop. Since the provisions of the POCSO Act are involved in the matter, the notice be issued upon the respondent number 2. Steps to be taken within a period of 7 days. This is the matter again on 8th of period of 7 days. List the matter again on the 15th of May 2026. Learned APP shall endeavor to have a service report. Report on the service of notice upon the respondent number 2. Apply for a certified copy or go in and take it from the legal aid. Once we record in the order that the legal aid is not giving you copies, everybody will be in trouble. Take a certified copy. We have fixed it on the 15th of May for service report. Huh?
Earlier order, all other cases were like registry.
To whom? Official survey copy to the college. Yeah, go order it. PPT survey copy বুলি কোৱা নাছিল জানো? হা? Registry would furnish a copy. হ'ব? To the learned amicus.
Notice was issued upon respondent number 2 and LCR was called for lordship in this case.
Yes, notice was issued thereafter. What happened?
We have taken step lordship.
You have taken steps. When? You cannot solve steps.
On 16/5/25 lordship. 16/5/25 lordship. Through PP.
True?
PP lord. We have served copy here.
That is the order. Mr. Parashar, APP has sought for accommodation to verify the status of the service of notice upon the respondent number 2. Full stop. Accordingly, list this matter again on the 4th of May. Please read this.
45.
We refuse to hear you. You should stand on this side for the time being. Change. Yes.
File by DP Goswami. He is in Delhi for wife's treatment. Malat. Maybe file is with him because of that file is not today. Malat. Maybe it's after 10 days.
It is submitted that the concerned APP who was dealing with the present matter is out of station today. Accordingly, list this matter again on when?
After 10 days, Malat.
We'll have it on the 15th of May.
Well,
Huh? On the 15th of May. Yes,
So this I is for condonation of delay, 111 days delay. Matter related box or matter. Notice may go lordship.
This is a heard Miss Swensolana counsel paying for the petitioner. This is an.
I'm a legal aid counsel lordship.
Okay, as the who appears as the legal aid counsel in the matter. This is an application under Section 5 of the Limitation Act for condonation of delay of 111 days in filing the appeal. In filing the connected appeal in connection with the judgment and order dated 27/6/2025 passed by the Additional Session Judge cum Special Judge POCSO Morigaon, Assam. In POCSO case number so and so, है ना? Stop. The state of Assam is represented by the learned APP. Stop. Steps on the respondent number 2 be taken within a through the office of the learned APP be taken within a period of 7 days. 7 days from today. List the matter again on the 6th of May. Will you be able to do it? You take a steps. 6th of May with service report. You got to have the service report confirmed. 6th of May.
Only one. 49.
What is 49?
Only one file left.
Could you find out?
In the case, they have obtained only from the order. We have 7/4/2026 by the magistrate. So magistrate petition
17/4, huh?
and this petition, bail petition file, I think, in 26th of March.
This one.
Item 49.
Huh?
Filed on 27th of March.
Huh?
So the council may not know,
No.
subsequently bail petition filing.
That is a subsequent bill petition.
Yes.
So we just want to know that if it is a subsequent bill petition, during pendency of this, we will have that bill rejected, recalled. Because it was during the pendency of this. Or should we remand it to the learned trial court to take into account the pendency of this bill petition? That this bill petition was pending when that order was given. Magistrate to make an inquiry as deemed fit, and if necessary, recall the aforesaid order by dismissing the said bill petition because of the pendency of this. And because he had approached another court, we'll dismiss this also.
Yes, if it fault of the petitioner, may not be, the advocate may not be knowing, but fault of the petitioner.
Difficulty you see is like this also. This court also has to see into this thing. That man is inside bars. Everybody outside is trying to have bill petitions filed to have him out from behind the bars. It may not even be in his knowledge that there are 2-3 bill petitions pending. In this case. They did not. I also did not inform there that there is another bill petition pending here.
No.
He would know the number of bill petitions pending. He has to send a CD.
Before High Court.
The only matter fixed we wanted to sit down and have a concrete mind what to do. Therefore, we are discussing that this can be done. We cannot overlook the shortcomings.
Well, yes.
No, the shortcomings to which this may have happened. First thought that comes to the mind is the brother is running on one part, the cousin is running with another advocate, the father is with another advocate. Everybody is trying at their own level. Firstly, what do you say in Hindi? Marta kya nahi karta. Everybody is trying. That is one aspect. Second aspect, the investigating officer. Why did he not know the number of bill petitions pending? Other petitions are tomorrow. Keep this for tomorrow. Keep this for tomorrow. Let me think over it. Don't want to do it in a hurry because at first or did you list this matter again on I led it to did you na tomorrow along with item 47 48 niki
842
can we inform the counselor 49 or counselor inform kori dibo kaile kane rakhisu let me find out what requires to be done in matters Because otherwise, this will keep happening. There was already an order from this court, if I remember correctly, that no other petition should be pending anywhere. Now, although I feel that the petitioner may not know it's sitting inside the jail who is filing what, every petition has to have a wakalatnama from the person in jail.
Yes.
He knows how many numbers he is signing. Will he not ask what happened to the other bail?
Hello, no. Hello.
It has to be. It has to be. Affidavit can be done by someone else. Even in the trial court. It has always to be by the accused. It cannot be that no, I am praying for bail for him. Can there be such petitions? Suppose the brother files a petition, making himself a party that I am against the state, praying for bail for my brother because he is inside. Find out in the trial court. I do not know. In our experience, long ago, father used to file the petition, praying for bail for the son. Rejected, allowed is another thing. Now, if the father is the petitioner, it will be his wakalatnama, not the wakalatnama of the person in jail. It has to be from the accused. No question about it. What about the lower court? You please try to find out. I remember fathers moving the petition, signing the wakalatnama. AB, there is no question. It has to be by the person concerned, affidavit by the person concerned, everything by the person concerned. In a bail petition, and I remember orders, this bail petition has been filed by so-and-so praying for bail, praying for grant of bail to so-and-so, his son. In that case, the father is filing the petition. Huh? That part my memory fails. We are only trying to streamline this. There is nothing else. Otherwise, some case filed in Sri Bhumi, how will you know what is happening here? We reject the bail. They've got a bail there. This is never in their knowledge. Tomorrow. Thank you.